Hello and welcome to BYJU'S IAS. Let's get started with the analysis of today's The Hindu newspaper, beginning with a news item on page number 1 of the Delhi edition of The Hindu, relevant for GS paper 1 as well as GS paper 2. Women army officers eligible for permanent commission, says the Supreme Court. Let's understand this newspaper article in great detail, and we will also be looking at the editorial in today's The Hindu newspaper. So this newspaper editorial and the newspaper article we are going to cover together. If we look at women officers were inducted in the army starting 1992. But initially only for a period of 5 years, that too in non-combat roles. Now what is a combat role? Combat roles are those involving engaging or fighting the enemy either in person or through equipment. For example, you are engaging with an enemy either hand to hand in hand to hand combat or through equipment, for example, artillery, missiles, so on and so forth. Women were inducted in the army starting 1992, but initially for 5 years. That too in non-combat roles. And which are these non-combat roles? For example, in Army Education Corps, similarly Corps of Engineers, etc., etc. This was called WSES scheme, Women Special Entry Scheme. In the year 2006, this Women Special Entry Scheme, it was replaced by Short Service Commission, which means you are commissioned in the army, but you will have a short service of 10 years. This can be extended by another 4 years. That means in total 14 years. Men were also recruited under short service commission, but once men completed 10 years, they could opt for permanent commission as well. And if you're commissioned into permanent commission, you can serve till your retirement. This permanent commission was excluded for women. To make it even simpler for you, there are two broad commissions. Either we have a short service commission, and if you're recruited in a short service commission, you can serve for up to 10 years. This can be extendable by another 4 years, but in total only for 14 years. But if you are recruited under permanent commission, if you are granted permanent commission, then you can serve the army till your retirement. This short service commission, both men as well as women were recruited under this. But men could opt for permanent commission, and if you were granted permanent commission, you could serve Indian Army till your retirement. This permanent commission was denied for women. And if women were kept out of permanent commission, that meant that they were also not qualified for pension. Because for an officer, you are eligible for government pension only and only if you have completed 20 years of service. Here, a woman officer could have completed a maximum of 14 years in service. That means they were ineligible for government pension as well. In the year 2003, a public interest litigation was filed before the Delhi High Court. Why? Please grant permanent commission to those women short service commission officers who have completed 10 years of service or 14 years of service. In the year 2008, the Defense Ministry issued an order. Defense Ministry order said that permanent commission will be granted to those SSC women, to those women officers of short service commission, but only in few fields, few areas. For example, Judge Advocate General, Army Education Corps. Judge Advocate General, basically the legal minds of the army. Those who play an important role during court-martial proceedings, for example. Those who advise army in legal matters. So in 2008, the Defense Ministry issued an order that permanent commission will be granted to SSC women officers, but only in few fields, in few areas. But there were two problems with this order. Number one, it was not granted in all areas. It was only granted in few areas. Number two, it was prospective in nature. The order was prospective in nature. It was not retrospective. What is the difference? The difference is that Defense Ministry said from now onwards, those women officers, those women short service commission officers who complete 10 years, they will be eligible. We will grant them permanent commission, but only in few areas, not in all areas. But what about those who already have completed 10 years? What about those who filed the case in 2003 and now their 10-year tenure is over? What about them? And that is why even this order was challenged before the court. The Delhi High Court in the year 2010 passed an order. It ruled in favor of a permanent commission for women SSC officers. That means in 2010, a decade ago, the Delhi High Court ruled in favor of granting permanent commission to those women who completed 10 years as short service commission officers. The government of India challenged this order before the Supreme Court and even did not implement this Delhi High Court order of 2010, despite the fact that the High Court order was not stayed by the Supreme Court. There was no stay at all. The case was going on. Now in February 2019, the government of India issued another order. This time the government of India is saying that we will grant permanent commission to SSC women, but in 8 areas, in 8 fields. Not in the all 10 fields, but only in 8 areas. But women officers will not be given command posts where they will command a battalion. The government order also said that women SSC officers, once they are granted permanent commission, they will serve only in staff posts. And if they are serving only in staff posts, that means women officers would not have gone beyond the rank of a colonel. So this 2010 High Court order, which was challenged in the Supreme Court, yesterday Supreme Court ruled in favor of women. Supreme Court yesterday ruled that women can serve as army commanders. Supreme Court dismissed the Government of India position because Government of India had told the Supreme Court that male soldiers were not ready to accept the orders from the female officers. Supreme Court said that this position of the government is very, very disturbing. Supreme Court ordered that the government now, you will have to extend permanent commission to women officers in all 10 areas. The government had said that men and women are physically different. When they are physically different, therefore they cannot be treated equally. But the Supreme Court dismissed all the arguments of the government of India. However, Supreme Court did rule that women can also serve as commanders, army commanders. But Supreme Court did not order that women be deployed in combat role. The Supreme Court said that the army should rule on this matter, the army should decide on this matter. Because the exclusion of women from combat operations, it was not examined by the court because it was not contested in this appeal. Which means the Supreme Court did not order that women be deployed in combat operations, because the court said army or the competent authority will decide on case-to-case basis. But the Supreme Court did say if you are completely excluding women from combat operations, that may not stand the test of judicial scrutiny. But the Supreme Court left it to the competent authority, to the army, to decide on case-to-case basis. Let's look at some of the other important things related to this newspaper article. The Government of India had told the Supreme Court that we should not provide commander role to women. That means women should not be made commanders. Why? Because the soldiers of the Indian Army predominantly come from rural India, rural areas, and they are not yet ready to accept orders from women officers. But if you look at police or CRPF, for example, men who are part of police as constables or CRPF constables who are men, they also come from rural areas. But we have had women superintendent of the police. We have had women DGPs as well. We have had women police officers as well. So if men constables who predominantly come from rural areas, if they can accept the orders from female police officers or female paramilitary officers, then what stops men from rural areas who are posted in the army from accepting the orders of the woman officer? By that logic, male paramedical staff who are working in hospitals, for example, they should also refuse to take orders from women doctors. or male peons or teachers in schools, they should stop taking orders from women principals? If rural Indian men can work under women in thousand other organizations, then there is no reason to believe that they cannot do so in the army. The fact is that a man is today joining army to serve the nation. But once a man joins the army, it does not give him some extra shot of testosterone. It does not give him any refresher course in misogyny. If you look at banks, many bank managers are women, and security guards at these banks are mostly ex-servicemen. So if these ex-servicemen, they take the orders of the female bank managers, there is no reason to understand why these male army members would not take the orders of a female army officer in command. But what about Indian Air Force? What about Navy? Both Indian Air Force as well as Navy, they previously offered permanent commission to women. And Indian Air Force pilots also have been women. So Indian Air Force and Navy, they offer permanent commission to the women as well as select combat role for women as well. There are few countries which allow women in combat roles as well. For example, Australia, Germany, Israel, and United States. There were some sexist arguments also made by the government before the court. The government said that army officers are to be kept in isolation. They have to face a lot of hardships, and that means women will not be in a position to survive in those conditions. Similarly, women have to answer the call of the nature. They will have to heed the call of pregnancy, childbirth, family. These were sexist arguments made by the government before the Supreme Court. The government affidavit also said that women ran the risk of capture by enemy and taken as prisoners of war. But all these arguments were dismissed by the Supreme Court. But despite this order, this Hindu editorial is very pessimist. It says there are only 1,653 officers in the Indian Army out of the total of 40,825. The editorial says that implementation and change are not likely to happen soon, despite the fact that Supreme Court has given a period of 3 months for the government to implement these orders. That is what you need to understand from this newspaper article and the editorial. Now let's look at another newspaper article on page number 1, and we will look at this article together with another column, Protecting Children's Right to Protest. Ever since the enactment of Citizenship Amendment Act, there have been protests at multiple places in this country. Bengaluru, Chennai, Delhi, Indore, Mumbai, many places. But the unique thing about these protests is that these protests have been led by women, particularly Muslim women. If you look at the Shaheen Bagh in Delhi, women in Indore, women in Chennai, these protests have been largely led by women. But there have been some concerns as well. These protests have also blocked roads at some places. So if you have a fundamental right of freedom of speech and expression, but it is not an absolute fundamental right, it comes under reasonable restrictions. One such reasonable restriction is public order. And if you're blocking roads, you are violating public order as well. Another concern is with the presence of children at these protests. We have witnessed that a 4-month infant in Shaheen Bagh in Delhi died because the mother of the infant was participating in the protest. The child was exposed to cold and ultimately died. The Supreme Court took a suo motu cognizance of this matter. The Supreme Court expressed surprise and concern as to how children could participate in these protests and how children were exposed to unfavorable climatic conditions, weather conditions. But what Supreme Court has done yesterday? Supreme Court yesterday conceded that mothers have the right to protest. Children have the right to protest. Ordinary people have the right to protest against any form of injustice, against any law, even if they don't want to wait for the Supreme Court to decide whether CAA is constitutional or not. They want to explore other means of protest. They are free to do that. But please don't block roads. And what Supreme Court has now done, it has appointed a senior advocate, Sanjay Hegde, that you please act as a mediator. Another lawyer, Sadhana Ramachandran, will also be part of Sanjay Hegde-led committee so that these two individuals can talk to the protesters at Shaheen Bagh, maybe try and persuade them if you can shift to another protest location, because right now you're blocking roads. You have the right to protest, but please don't block roads. The court also has left it to the discretion of Mr. Sanjay Hegde that you may also include previous chairperson of Information Commission, Wajahat Habibullah, so that you all three will try and persuade the protesters at the Shaheen Bagh that you should shift to another location, another protest site, and not block the roads. But what about this column? When Supreme Court took a suo motu cognizance of the fact that a child has died when the child was exposed to cold conditions at the Shaheen Bagh protest site, the court took it upon itself to decide whether children can participate in protests or not. And this newspaper column justifies the participation of children in protests. Why? Number one, Article 19. Article 19 talks about every single citizen in this country is provided freedom of speech and expression. It does not talk about age. That means when all the citizens in this country have the right to freedom of speech and expression, to articulate themselves, which includes the right to protest, it does not talk about age. So children also have the fundamental right to protest. Children also have the fundamental right to express themselves. Number two, India is also a signatory to United Nations Convention on the Rights of the Child. And Article 13 of this convention explicitly states that children have the right, have the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally in writing or in print, in the form of art or through any other media of child's choice. That means this Article 13 of this convention also gives the right to the children that you can also democratically participate in the protest. You can also seek information about anything and everything. Argument number three, there are schools which encourage children that you should read newspapers, you should watch news channels. Attending a protest is also a way for a child to receive information and ideas. Because at a protest site, they get to witness different expressions of discontent. Because a protest is also a space where children, they get to experience and assert their citizenship. This column also says that a child has the right to be present because the child is a stakeholder at these Shaheen Bagh protests. Why? Because these protests are also against Citizenship Amendment Act, also against NRC. And in NRC, you will have to prove through documents whether you are Indian or not. And if the mother or the father of a child is not in a position to produce documents through which this individual can claim Indian citizenship, that means this father or mother of a child will be declared as illegal migrant. That will affect the citizenship of this child as well. Because according to the citizenship law, a child born in India after 1987, this child will be an Indian provided one of the parent is an Indian and the other is not an illegal immigrant at the time of the birth. So if the father or the mother of this child is protesting at Shaheen Bagh against NRC, wherein because of NRC, once it is implemented, the father and the mother will have to prove their Indian citizenship through documents. And if the parents are unable to prove through documents that they are Indians, it is going to affect the citizenship of child as well. That means it is the right of a child to be present at these protest sites, because he is the stakeholder in these things as well. That is what you need to understand from this newspaper article and column. Now let's look at State of India's Birds 2020 report. This report was released at the United Nations backed 13th Conference of Parties of the Convention of the Conservation of Migratory Species of Wild Animals. According to this report, the numbers of India's national bird, peacock, have increased over the last few decades. Vultures, eagles, their numbers have decreased. This report identifies two types of species. Those who are doing relatively well, those species who are doing relatively well in terms of their population, and those species who are at conservation concern. That means they are at high risk. If you look at this report says that 40% of the bird species, they have remained stable in the last 5 years. But 101 species, they have been classified as high conservation concern. One important thing, house sparrows or common sparrow. There was a popular notion that the population of house sparrows is declining. Why? One big reason thought was the radiation coming out from mobile phone towers. But this report says that this factor, radiation coming from mobile phone towers, is not supported by evidence. Yes, if we look at the urban areas, metros for example, there is a declining population of house sparrows. But the reason for that is paucity or shortage of nesting sites. The reason is also declining insect population. Why? Because this is one of the important diet of sparrows. So if there was a popular notion that population of house sparrows is declining, that's not true. The population is stable so far as house sparrows are concerned. But yes, in urban areas, there is a declining population, and these two are the major reasons for that, not the radiation coming out from mobile phone towers. Which are these bird species which have shown declining population, declining number? Raptors, migratory shorebirds, and habitat specialist. These include white-rumped vulture, Richard's pipit, Indian vulture, large-billed leaf warbler, Pacific golden plover, curlew sandpiper. These are the species which have shown declined numbers. And which are these species which have shown increasing numbers? Rosy starling, feral pigeon, glossy ibis, plain prenia, ashy prenia. These can be important statements so far as your prelims is concerned. What about peafowl? This is spread across the hills and plains of India, except in the extremely dry and extremely wet regions. Peafowl, they are present across hills and plains of India, except in extremely wet and extremely dry regions. This bird has been found even in Kerala now, where it was absent in the past. Very important statement, can be relevant for your prelims examination. The four species of bustards in India, the Great Indian Bustard, McQueen's Bustard, Lesser Florican, Bengal Florican, they have all suffered continuous population decline, primarily because of hunting, primarily because of habitat loss, and together their slow growth and reproduction. These are the reasons why the population of the bustards in India is declining. Great Indian Bustard, it is also mentioned as critically endangered in the IUCN Red List of 2019. Vultures, for example, their population is declining primarily because of diclofenac. What is diclofenac? Diclofenac is used by the cattle. It is basically an anti-inflammation drug. And when this drug is administered to the cattle, then these cattle, they die. Their carcass is fed by vultures, and these vultures are then exposed to diclofenac, and this diclofenac is responsible for the declining population of vultures. Now let's look at some of the editorials and columns from today's newspaper. The first one, India's disturbing trauma narrative. You don't have to read this column in detail. I'll tell you the crux of this newspaper column and also where it can be used. Tomorrow in your mains examination, if there is a question asked on the misuse of the sedition law, this is the example that you can cite. At a school in Bidar in Karnataka, at the annual day celebration, a play was performed. When this play was performed, an 11-year-old had made some remarks. And because of these remarks, the principal of the school as well as the mother of this child, they were booked under sedition. Why? What exactly had the child said that merited sedition charge slapped on the principal and the mother of the child? The child had said, the boy who was selling tea till the other day is asking us for documents. I'll ask him where he was born and where his papers are. If he does not provide them, I will beat him with my slippers. These slippers were seized by the police and sedition charges were slapped against the mother of the child because it is alleged that this mother is responsible for writing these words, and principal allowed this play to be carried out, to be performed at the annual day celebration. So the allegation is that in these lines, the child is referring to the Prime Minister. But even if the child is referring to the Prime Minister, clearly it is not sedition. Sedition is a serious charge. Unless and until there is incitement to violence, it can't be sedition. That's what the Supreme Court has repeatedly said. And the police has seized the pair of slippers, which basically means that these slippers could be used to incite violence against the Prime Minister. That is why it is sedition. It is blatant misuse of Section 124 capital A of Indian Penal Code. That is what this newspaper column is all about. So you can cite this example if there is a question asked on the misuse of the sedition law. Now let's look at another editorial, a royal mess. This is related to the AGR, adjusted gross revenue, the dispute between the telecom companies and the government. This we have discussed in detail in our 15th February 2020 The Hindu newspaper analysis. But I'm not going to explain what this AGR means and why Supreme Court ruled in this matter, because that we have covered comprehensively on this particular date. I'm going to talk about something else. When the Supreme Court said that these telecom operators who owe these dues to the government, they will have to submit these dues by midnight, there are some people who argue that this is a classic case of judicial overreach. These critics say that there are multiple cases where the Supreme Court is not showing the same alarcity as it is showing in this case. Which are these cases? For example, electoral bond scheme. Since it was launched in 2017, there have been repeated petitions against this electoral bond scheme. The petitioners are arguing that this scheme violates free and fair election, which is part of the basic structure of Indian Constitution. But Supreme Court is not showing the same alarcity in disposing of this case. Similarly, there are a number of habeas corpus petitions pending before the Supreme Court dealing with Jammu and Kashmir. These cases have been delayed. The challenge to Citizenship Amendment Act, the Supreme Court is not showing alarcity in hearing these cases despite the fact that there have been repeated protests, nationwide protests against CAA. So all these can be cited as the cases of judicial evasion, where the judiciary is not acting on these matters at all. But there are other cases of judicial overreach. For example, few years ago, the Supreme Court said all these bars, all these liquor shops within 500 meters of national highways, they should be closed. Why? Because we have to stop the menace of, we have to stop the incidence of traffic accidents along the national highways. In some instances, the Supreme Court issued order to tackle monkey menace in Delhi. In another instance, the Supreme Court issued orders on the use of seat belts by the drivers. And now this order, wherein it asked all these telecom companies to pay their dues that they owe to the government by midnight, without considering the repercussions of this order. What are these repercussions? The biggest loser in all this would be Vodafone-Idea. And in all likelihood, the Vodafone-Idea will go bankrupt and it will stop its services in India. And if Vodafone-Idea stops its services in India, it is going to affect our investment climate, and global investors will be very wary of investing in India. Second, it is going to create a duopoly. That means in our telecom sector, we will only have Airtel and then Reliance Jio, which goes against competition. Third, what about the 15,000 job losses that will result if Vodafone-Idea shuts its shop in India? Does Supreme Court even consider all these repercussions before ordering judgments of this kind? What about banks who are exposed to Vodafone-Idea, who have lent crores and crores of rupees to Vodafone-Idea? What about future 5G trials? When this 5G spectrum will be auctioned by the government, and if there are only two players in the market apart from the state-owned BSNL, it is going to accrue less and less revenue to the government of India. This editorial does criticize even these telecom companies as well. If these telecom companies would have paid their annual dues yearly basis, they would not have been confronted with such a situation where they owe more than 1 lakh crores to the government. So how can we solve this royal mess? The ball is in the court of the government according to this editorial. The parliament may pass a law so as to allow these telecom companies to make payments but over a period of time, or the government may reduce the adjusted gross revenue based license fee or spectrum usage charge. This is the only way. Prudence is the only way. Pragmatism is the only way to come out of this royal mess. That is what you need to understand from this editorial. Now let's look at this column. If we look at the distribution of powers mentioned under Schedule 7 of the Constitution of India, subjects such as police, law and order, prisons, they fall under state list. So all the states have their own police force. But in addition to these state police forces, the center manages 7 police organizations as well. Which are these 7 police organizations of the center? CRPF, Central Industrial Security Force, Railway Protection Force, Sashastra Seema Bal, Border Security Force, Indo-Tibetan Border Police, Assam Rifles. This column is about CRPF. CRPF prior to the independence was called CRP, Crown Representative Police. This police was established in 1939. At the time of the independence, the future of CRP was under discussion. Since law and order was under state subject, almost everyone questioned the continuance of this police force. But Sardar Patel was in favor of retaining CRP, and that is why in 1949 this CRP became Central Reserve Police Force. At the time of the independence, CRP had only 2 battalions. Today CRPF has 246 battalions. What is the mission of CRPF? The mission of CRPF shall be to enable the government to maintain rule of law, public order and internal security effectively and efficiently, to preserve the national integrity, promote social harmony and development by upholding the supremacy of the Constitution. But today's CRPF personnel, they are under stress. How do we know that? There is increasing rate of incidents of suicides. Not just suicides, fratricides as well, wherein the CRPF personnel, they kill each other. For example, a CRPF Jawan is denied leave by his superior officer. He opens his gun and then kills his superior officer as well. These incidents of suicides and fratricides, they have been on increase. So what is the solution? Home Minister says that we will ensure that every CRPF Jawan is provided 100 days leave in a year so that he gets to spend some time with his family, and his family members will also be provided health insurance. This column says that this 100-day leave is an impossible dream for a soldier. So what should be done? This column says, let's say CRPF personnel, they are posted in insurgency hit areas. They are tasked with maintenance of law and order. BSF guards our borders. CISF, for example, provides security to our airports and our public sector undertakings, for example. What this column says, that instead of saying that all CRPF personnel should forever their time, forever till their retirement, focus on law and order and in anti-insurgency operations, this should be done away with. What this column says, that all those who are recruited to these 7 central police organizations, for 15 years, they should be deployed in anti-insurgency areas. That means whoever is recruited to these 7 central police organizations for 15 years, you should be devoted, you should be deployed to anti-insurgency areas. Then for the next 10 years, you should be deployed to border areas. Then towards the end of your service, you may be deployed so that you are taking care of airport security or providing security to PSUs. Because as of now, today, if you are recruited in CRPF, throughout your term, throughout your tenure, you are dealing with law and order problems and anti-insurgency cases. That means till the last day of your service, you are in high risk job. This can be avoided if we are following this system. That's one reform. Second, a large number of individuals, personnel, they are taking voluntary retirement. But there is no rehabilitation policy. How should we rehabilitate those who have voluntarily opted for retirement? That should be another thing that the government should look into. Although there is a welfare and rehabilitation board, but it has not made any impact according to the author. Another demand that should be considered is that of OROP, one rank, one pension. Another demand, for example, who is the head of the CRPF? Basically, an IPS officer is deputed to head this CRPF. The column says, why can't we ensure that the senior officers who are recruited to CRPF, one amongst them gets to head this force? What about this non-functional financial upgradation? This is something that was recommended by 6th Pay Commission. What is this non-functional financial upgradation? Initially, it was for IAS officers. What is this non-functional financial upgradation? Let me make it simpler for you. Let's say, for example, this is an IAS officer of 1990 batch. This IAS officer is promoted as additional secretary to the government of India. That means once he is promoted, he gets a better salary as well. But what about the other officers of the same 1990 batch who are not promoted? That means they lose out on salary benefits. This non-functional financial upgradation was recommended for IAS officers. That means even if other batch members, they are not promoted to a higher post, they will still draw the upgraded salary. This was recommended by 6th Pay Commission. This was also recommended for on the orders of the court to the CRPF personnel. But this column says, because the head of the CRPF is an IPS, this non-functional financial upgradation has not been implemented since we are marking 1 year of the dastardly attack in Pulwama, wherein more than 40 CRPF Jawans lost their life in a dastardly suicide bomb attack. This column says the functioning of the CRPF needs to be revisited. That is what you need to understand from this column. Now let's look at the practice questions. First, prelims based and then mains based. Question number 1. Which of the following measures were undertaken by Akbar for the benefit of his Hindu subjects? He abolished jizya, yes. He abolished the pilgrim tax. He assigned land revenue to Hindu mutts. He banned forcible conversion. He abolished Gari and Chari tax. No. These taxes were imposed by Alauddin Khilji, and these were stopped by Feroz Tughlaq. So what is the correct answer? A. 1, 2, 3 and 4. With reference to Vijayanagara architecture, consider the following statements. Number 1. Construction of the tall Raya Gopurams and Kalyan Mandapam with carved pillars are the important features of this school of architecture. Correct? Vittala Swami and Hazara Ramaswamy temples are examples of this style of architecture. Both these statements are correct. Question number 3. With reference to the servants of India society, consider the following statements. Gopal Krishna Gokhale founded the society. Yes. Gopal Krishna Gokhale is also considered as political guru of Mahatma Gandhi. It was the social arm of Indian National Congress. No. At present, it works for providing education to tribal girls. Yes, this statement is correct. So 1 and 3 is correct. C is the correct option. With reference to OECD, Organization for Economic Cooperation and Development, consider the following statements. It is a group of high-income countries founded in 1961, correct? It publishes the International Migration Outlook Report, correct? India has been an observer member of this organization. No, India is neither a member nor an observer, but it is a key economic partner of OECD. So which of the above statements are correct? 1 and 2 only. Which of the following best describe Google's Station program? It is Google's fast and free public Wi-Fi program. What is the context? Google has said that we are going to end this Station program. Mains based question. Number 1. The oft quoted argument of lower physical standards of women is no longer valid in modern warfare and combat. Elaborate in light of the recent Supreme Court ruling on Permanent Commission for Women. Question number 2. United States should prepare for the possibility of a socialist in the White House. Comment. That is it from our newspaper analysis for today. Thank you for being with us. Have a great day.